Good morning. This is the summary of the judgment in the case of the Queen on the application of Fylde Coast Farms Ltd, formerly Oyston Estates Ltd, against Fylde Borough Council. The law governing planning permission depends on development plans adopted by local planning authorities. The Localism Act 2011 introduced a new procedure for the creation of neighbourhood development plans. The procedure allows for greater direct public involvement by making the adoption of a proposed neighbourhood plan depend on the outcome of a referendum of the local population. A series of steps has to be followed. Following the making of a proposal for a plan, an independent examiner reports on it. In the light of that, the local authority decides in what form the proposal should be put to a vote in a referendum. The Localism Act introduced a series of strict time limits for challenging the making of a neighbourhood plan, assessed by reference to the timing of particular stages at which it is alleged a legal mistake has occurred. This appeal is concerned with the proper interpretation of those time limits. A proposal for a neighbourhood plan for St Anne's-on-the-Sea, near Blackpool, was put forward which did not include a site owned by the appellant, Oyston Estates. Oyston wanted to develop the site for housing. The independent examiner recommended that the draft plan be amended to include the Oyston site. However, the local authority, Fylde Borough Council, decided not to accept that recommendation. Instead, it referred the plan in unamended form to a referendum. The plan was approved by a large majority and in due course came into effect. After that, Oyston began a judicial review claim to quash the plan. Its case was that the council had acted unlawfully when it refused to accept the recommendation of the independent examiner to incorporate the Oyston site in the proposed neighbourhood plan to be put to the referendum. If one calculated time from when the plan came into effect, Oyston was within the 6-week time limit applicable at that final stage. However, if one calculated time from when the alleged legal error occurred, at the stage when the council decided not to accept the examiner's recommendation, Oyston was outside the 6-week time limit applicable to that stage. The question which arises on the appeal is whether, on the proper interpretation of the time limits provision, Oyston was entitled to wait until the end of the plan-making process and then had 6 weeks to make its challenge, or whether it was obliged to get on and make its challenge based on the earlier stage in the process within 6 weeks of that stage. The High Court and the Court of Appeal both held that Oyston was not entitled to wait to the end of the whole process after the referendum before bringing its challenge. It was therefore out of time under the statute. By a unanimous decision, the Supreme Court agrees with this and dismisses Oyston's appeal. The Court finds that the wording of the statute is clear. For a legal challenge directed to what has happened at the stage of consideration of the examiner's report, the provision says that, quotes, a court may entertain proceedings only if, end quote, the complaint is brought within 6 weeks of that event. A challenger is not entitled to wait until the end of the whole process if they want to rely on a challenge of that kind. The inference is that Parliament set this strict form of time limit so as to avoid a situation where a referendum might be held and then have to be treated as having no effect because of the impact of a legal problem which arose before the referendum took place and could have been sorted out beforehand. That would have risked creating disaffection with the new referendum procedure, which could undermine rather than promote public engagement with setting neighbourhoods plans, contrary to Parliament's overall objective. The Court is now adjourned.